What a better way to finish out the week than to highlight a story out of the Illinois Supreme Court dealing with a bicyclist suing the city of Chicago for hitting a pothole and the arguments back and forth. So let's go ahead and get on into that. This is Stephen Collins, a attorney representing Chicago, talking about how the plaintiff in this case, who hit a pothole, was riding his bike on a city street that wasn't properly marked for people riding bikes. So what's the rationale behind working to deny that they have any liability as the city of Chicago with potholes all over the place?
May it please the court, I'm Stephen Collins, and I represent the city of Chicago. The city uses street signs and pavement markings to specify which of its roadways are intended for bicycle use. There were no such signs or markings at the location of Mr. Olave's bicycle accident. Accordingly, Mr. Olave was not an intended user of the roadway, and the city did not owe him a duty. Now, the appellate court's contrary decision, which relied largely on the presence of a divvy bicycle sharing station in the vicinity of Mr. Olave's accident, is not consistent with this court's precedents. The court made clear in Baub that it determines the intended use of a roadway by looking to affirmative manifestations of municipal intent.
How is having authorizing this station not an affirmative manifestation of intent?
It's not, Your Honor, because a divvy station by its nature does not designate any particular roadway as being intended for bicycle riding.
So part of the argument here is the plaintiff says, hey, I should have been able to ride my bike on the streets that I ultimately hit a pothole in because there was a divvy bike rental station sanctioned by the city within, quote, throwing distance. And that's an indication that, hey, these streets are okay to ride bikes on. But the city pushed back on that, saying, oh, that's not the case. Just because a divvy bike station's there doesn't mean you can ride bikes anywhere. The plaintiff's attorney, Aaron Fisher, says that that just doesn't make any sense. And then you stack on top of that Chicago claims to be the most bike-friendly city in America. Well, that's got people kind of scratching their heads here.
What we're saying is to establish the city's intent, looking at Baub, Wedelia, Vaughan, you have to look to the nature of the area. And you're right, looking to the nature of the area does not delineate the furthest west or the furthest east. But in this particular case, the nature of the area was a bike rental business owned and operated by the city. A person who gets on a bike in Chicago does so with all the advertising and all the notice that Chicago is a bicycle-friendly city. They do so with Chicago claiming to be the most bicycle-friendly city in the country. So it is a bit odd that if you park in your alley where people keep bikes in garages and you get on your bike, that the city's duty is willful and wanton until you reach a bike lane. But this happened next to a bike rental station. It's a lot less vague than someone parking in their garage and trying to commute to a bike lane, in my thoughts, Judge.
Are you arguing that the city has a duty to maintain every single street in the city of Chicago, or else they're exposed to liability, despite the Tort Immunity Act?
No, I don't believe that's the law, and I'm not arguing for that change in law.
So what is the ruling that you want?
I'm arguing that directly next to divvy stations, where the city has manifested its intent for bicycles to be used, purchased, rented, driven away, that area in particular should have a duty of reasonable care. And limited to the areas cited by the Supreme Court, the appellate court, from the divvy rental station to the nearest bike lane. Had my client continued, he would have ended up on a bike lane, and that's a question of fact, but obviously that's what would have happened.
But again, he also noted that the city proclaims itself as the most bike-friendly city in America. City of Chicago. So the Supreme Court took that case under advisement. They had a busy couple of weeks hearing all kinds of cases. So hopefully you're more informed about the types of things that the Illinois Supreme Court has taken up. I'm out of here. Have yourselves a great weekend. We'll see you back here on Monday morning, bright and early, 6 to 9. It is WMAY.
From the Fly SPI Studios, take